In short, yes, a college or university can impose an interim suspension or a temporary suspension on a respondent under the Title IX final rule. That being said, schools are obligated to have a Title IX grievance process that is to be followed before any, say, adverse action is taken against the respondent. This is a gray area in terms of course, it's an adverse action if a respondent were to be suspended on a temporary basis from the school. That being said, a school would or should do a balancing test, bearing in mind the obligation to protect the complainant based on the allegations, the campus as a whole, the campus body that is, taking into account those interests and balancing them against the respondent's interest to remain a student, to continue going to class, for example, while the allegations are being addressed and adjudicated. A school can impose an interim suspension or a temporary suspension against a respondent. This does come up from time to time. As to if the school is in its rights to doing so, that's a separate consideration altogether, and also as to what processes the school should take to allow a respondent to address or to seek recourse in terms of having that decision reconsidered also needs to be kept in mind in terms of what's appropriate to the circumstances. When accused of a Title IX sexual misconduct allegation, it's an incredibly serious circumstance. You have to bear in mind the potential implications and potential consequences. An experienced attorney advisor will be your best ally in terms of navigating and understanding the process, and they'll be able to work towards trying to ensure a fair process and a favorable outcome. They should be involved as early as possible in a Title IX case.